All rise. Oh yes, oh yes, oh yes. This Honorable Superior Court for the 26th Judicial District of the State of North Carolina is now in session. The Honorable Louis A. Bledsoe III, the judge presiding. Proceed to come to order.
Thank you. Good morning.
Good morning.
All right, let me get myself organized here. All right. We're here today for a hearing in Mecklenburg County Superior Court case number 2023 CBS 40918, which is captioned the Atlantic Coast Conference versus the Board of Trustees of Florida State University. We're here on three motions on the defendant Board of Trustees of Florida State University's motion to dismiss. We're in the alternative stating action, which is ECF number 19 on the business court docket. Plaintiff Atlantic Coast Conference amended motion to seal, which is ECF number 9 on the business court docket. And plaintiff Atlantic Coast Conference's motion to seal summary exhibit ECF number 24.2, which is ECF number 25 on the business court docket. We're also here for a business court rule 9.3 case management conference. The court personnel joining me in today's hearing include our bailiffs, Deputy Flores in the back, Deputy Roberson over to my right and your left, my career clerk, Lauren Shantz, over here in the witness box, our courtroom clerk from the Mecklenburg County Clerk's Office, Shade Johnson, and we have our court reporter, Joyce Hughesby. Before we begin our arguments, and so that our record is clear, I would appreciate you all announcing your appearances. Plaintiff first, defendant next, and then ESPN.
Good morning, Your Honor. My name is Jim Cooney. I'm a member of the Mecklenburg County Bar with Womble Bond Dickinson. I represent the plaintiff, the Atlantic Coast Conference. I'm joined at council table by Pearl Howe, who is the general counsel for the Atlantic Coast Conference, Alan Lawson of the Bar Florida, who you've admitted pro hoc vice. Mr. Lawson is with the law firm of Lawson, Huck & Gonzalez in Tallahassee, and Sarah Stone Motley of our firm, Patrick Spa of our firm, and Caroline Cooney, who is my paralegal, but also moonlights as my daughter.
All right. Thank you, Mr. King. Mr. King.
Your Honor, Bailey King from the law firm of Bradley here on behalf of the the Florida State University Board of Trustees. Yeah, sorry.
You can join us.
I'm glad I got that one out of the way. Made my mistake. With me are my partner Chris Lamb and Carolyn Egan from the Florida State University General Counsel. Also with us from Greenberg Trowey are David Ashburn and Pete Rush, and then from our firm with us, Hannah Eichmeyer and Brian Lawson.
All right, thank you, Mr. King.
Good morning, Your Honor. James McLaughlin from Warren Van Allen for ESPN. With me is my partner, Bill Butler, from Warren Van Allen, and David Korn from Cravath, Swain and Moore will be arguing for ESPN.
All right, thank you, Mr. McLaughlin. All right, a few housekeeping details before we begin. First, we're going to follow the proposed hearing schedule that the parties in the court worked out and finalized by email on March 14th. That means we will hear first Florida State's motion to dismiss, or the alternative stating action, and in connection with that motion, the ACC and FSU will each be permitted 1 hour to present their arguments. We'll then hear the ACC's amended motion to seal, which is ECF number 9, and the motion to seal the summary exhibit. The summary exhibit is ECF number 24.2. And the ACC and FSU will each have 20 minutes on that motion, and ESPN will have 10 minutes on those motions. So the sealing motions are 20 each for ACC and FSU, and 10 minutes for ESPN. After the sealing motions have been heard, we will then have our business court Rule 9.3 case management conference. The parties have estimated that that'll take 15 to 30 minutes, and we'll see where that goes. The parties will be expected to observe the time limits for each motion as reflected on the schedule I just outlined. Ms. Shantz will be the official timekeeper for the hearing. She will notify the parties when a party has 5 minutes of argument time left on a particular motion. She'll give a notice again at 2 minutes, 1 minute, and then when the time period is up. I'll plan to take a 10 to 15 minute break at a convenient time about halfway through the proceeding. Otherwise, I plow for us to plow ahead and hopefully be finished no later than 1 o'clock or 1:15 at the latest. Based on the parties' representations upon my inquiry, that no party expects to present material that has been designated as confidential during today's presentations, as well as the parties' agreement that the courtroom does not need to be closed for any portion of today's proceeding. I do not intend to close the courtroom today. I have received and approved an application by WSOC-TV to make a video recording of the proceeding today pursuant to Rule 15 of the General Rules for practice in the Superior District Courts, and also consistent with the 26 Judicial Districts local rules governing photography, filming, and audio recording within the Mecklenburg County Courthouse. I have not received any other applications to film or otherwise record today's proceedings, so please be advised that taking photographs, filming, or recording of audio by means of cameras, cell phones, smartphones, tablets, or any other electronic or mechanical device is prohibited, and violators of this rule are subject to the contempt powers of the court. Are there any questions or comments from the parties before we begin the arguments on the first motion on for hearing today?
One quick question, Your Honor, on the time limits. Do you want us to tell Ms. Shantz how we want to allocate it, or
Certainly.
we just kind of go and then kind of pick it up?
Well, I mean, the reality is that whatever you leave for rebuttal will be what you have left for rebuttal. Even if you declare at the outset that you're going to reserve next for rebuttal, so I'll let you manage that how you wish.
Thank you, Your Honor.
Each side will be in charge of arranging their own arguments such that Ms. Shantz is going to tell you when you run into your rebuttal time, you need to keep track of that yourself. Any other questions or comments before we start? All right. Let me say at the outset that I have spent several days now reading and studying your briefs, your supporting materials, your cited cases. And as I anticipated from the outstanding lawyers that are representing the parties in this case, and I'm not just saying that, the folks in the gallery should know these are very, very fine lawyers representing all three sides. And as I expected, they have done a very good job, an excellent job in setting forth their respective positions. I've also I've reviewed the demonstratives that both sides have submitted, or at least Florida State and the ACC have submitted. But despite all of that education that I've received from the parties, I do have a number of questions, and those who appear before me know that we often engage in a lot of back and forth discussion, and I anticipate we may do some of that today. So I encourage you to get to the heart of the matter in your arguments this morning, make effective use of your available time. In particular, it will be helpful for me and may serve to limit my questions, which would be a good thing since these are time-limited arguments. You can not only advance your affirmative arguments when you present your side, but also directly and squarely engage with the other side's arguments that they made in opposition to your position. All right, with that, I look forward to your arguments, and we'll turn to Florida State's motion to dismiss on the alternative to stay the action. Mr. King, looks like you're perched to argue for Florida State.
Yes, Your Honor. Bailey King here on behalf of the Florida State University Board of Trustees.
Mr. King, I'll hear from you.
With your comments, take those in mind. Your Honor, I'd like to really start by cutting to the chase and acknowledging exactly what this motion is and the reason we are here today on it. I don't think it is lost on anyone that this is a forum fight. As you know, the FSU board filed a competing lawsuit in Florida. That lawsuit was filed approximately 18 hours after the ACC initiated this lawsuit by filing its original complaint for declaratory judgment. Now, both sides, certainly the FSU board and also the ACC, they want to litigate the dispute on their home field. And I'd like to start by acknowledging there's nothing wrong with that. True plaintiffs, it's a long-standing principle, get to choose the forum. But in order to do so, Your Honor, you have to play by the rules of the game. And those rules include, in this case, two sources really, where we look at the rule book. First is the ACC's own rules that governing how their members are to operate vis-a-vis each other. That's the ACC Constitution and the bylaws. And then, as Your Honor is well aware, the rules governing civil litigation and how that operates. And that includes the United States Constitution and the case law interpreting it. And in that source of rules, I think I want to point out just from the outset that the first filed rule is a rule, but it's not the only rule. The rules also include standing, sovereign immunity, rightness, and the anticipatory filing doctrine. And in its attempt to try to secure a home field advantage, the ACC didn't follow those rules. Instead, the ACC raced to the courthouse to file a preemptive and premature lawsuit against the FSU board, one of its members, and it did so before it had standing to sue under its own constitution by not taking a vote, and it did so before the dispute was right under Article 3 of the U.S. Constitution. And finally, it did so in a court that lacks personal jurisdiction over Florida State University, a sovereign agency in the state of Florida. So, with that said, with apologies for the pun, we believe the ACC jumped off sides. That is a penalty. It certainly does not entitle the ACC to its home field. And we think, according to the well-established rules, it warrants dismissal or, at a minimum, a stay of this action. Now, because Your Honor said you've read the briefs, I don't feel like, and this is a forum fight, that we need to delve too deeply into the underlying facts of this dispute. But I do think it's helpful to put some context around those facts, especially given some of the arguments that the ACC has made. And so in doing so, I'm going to focus on the original complaint, ECF number 3. This is the filing that the ACC raced to the courthouse to file, admittedly, in order to secure this forum. And it did so on December 21st, only after it heard that the Florida State University Board was going to be meeting the next day. And it did so before taking a vote of its members. And it did that in order to race to the courthouse and be first filed. As you know, in the original complaint and in the amended complaint, the ACC is seeking a declaration regarding the enforceability of two documents, the 2013 grant of rights and the 2016 grant of rights. And I think we need to talk about the importance of these agreements, especially to the ACC. These are the agreements under which the ACC contends that Florida State and the other members of the ACC gave away their exclusive media rights to the ACC through 2036, a period of 20 years. And they did that so that the ACC, according to the allegations of the complaint, could negotiate a long-term deal on their behalf with ESPN. These are referred to in the briefing as the ESPN agreements, and ESPN has argued that they are among its most vital third-party contracts. They make up the vast majority of their revenue, and under which the ACC receives hundreds of millions of dollars. I think you also should look at the timing of the broader timing of when this lawsuit was filed. The ACC filed this lawsuit and is seeking this declaration during a time period in which it acknowledges that athletic conferences, like the ACC and others, are experiencing, quote, significant instability and realignment. The AC alleges that in this environment, the grants of rights were, quote, necessary to secure the ESPN agreements and to secure the ACC's ongoing stability and certainty. And then they filed it on December 21st, as I said, racing to the courthouse, expressly because Florida State had threatened to leave the conference during this period of realignment and instability. And finally, the stated goal of the ACC in this lawsuit is to prevent Florida State from leaving. Paragraph 127 of the complaint declaration, the complaint for declaratory judgment states that they are seeking a declaration that if Florida State leaves, the ACC keeps FSU's media rights for the next 12 years. So I think with that backdrop, it is fair to say that this dispute is going to impact the future of both Florida State and the ACC. I think it's fair to say that it involves hundreds of millions of dollars. And I think it is safe to say that from the outset, when the ACC filed this lawsuit, it was material litigation. For Florida State, at least, it's been widely reported that this is existential. According to the ACC, suing one of its members, it's a member institution, and suing one of those members in an attempt to hold that member hostage is immaterial. We'll talk about more of that as we get into arguments. But I would just say now that I think the ACC's watching, we learned in the declaration of President Ryan the other day, watching Florida State for a period of months and then racing to the courthouse and filing this lawsuit immediately upon receiving notice that the FSU board was going to meet suggests otherwise.
It sounds like you're arguing the motion to stay in the first filed rule out of the blocks as opposed to your motion to dismiss. Do we want to talk about that argument now?
Your Honor, I was going to address them all largely together
Okay.
because I do think that there is, they largely overlap, at least what I want to focus on today. What I want to focus on today, we made several arguments in our motion to dismiss, but are primarily the arguments about whether this court is the proper forum to hear this dispute. And I think those, the way I would say it is, they're jurisdictional, they're threshold issues, and we believe we win them. We feel strongly we win them, and that's what I will begin to argue. But if we lose them, if they're close calls, and your hunter goes the other way, certainly they all would factor in favor of a stay. So I think you can address them together. And so I'll answer obviously any questions your Honor has, but there's three I would plan to focus on. That's the standing issue, which as your Honor knows is a matter of subject matter jurisdiction, sovereign immunity, and then rightness. Again, like I said, I'm going to plan to address both the motion to dismiss and a stay at the same time because I think they overlap. And I think the standing, which is where I'd like to start, is the one where that's most obvious.
All right.
So the first things I would say about, to clarify a few things in the briefing, I think, is that the place we are at now on this standing issue, the ACC did not conduct a vote to get the approval of its members before filing a lawsuit against one of its co-members, Florida State. We know that. We did not know that at the time we filed our initial motion to dismiss. It's a pleading issue. But because this is a subject matter jurisdiction issue, the court can and should look outside of the pleadings, and we now have two affidavits from the ACC in which they seek to establish the authority to sue under their constitutional documents. And so, but that was based on a vote that was taken on January 12th, 3 weeks after this lawsuit was filed, approximately 3 weeks after Florida State filed its lawsuit. And so if standing exists based on that vote, it does not exist until January 12th. They are not the first filed. And so this is why this actually does relate to the motion to stay.
Let me ask you about that. I mean, you indicated in your brief that just what you said, that is that there was not standing at the initiation of the lawsuit, but that if there was standing by virtue of anything the ACC did, it was as of January 17 when they filed their first amendment complaint. North Carolina law does say that if there's a lack of subject matter jurisdiction, if there's no standing to bring a lawsuit, then the lawsuit that's filed is a legal nullity. How is it then that it could be revived? Now, recognizing that the ACC's got an argument about retroactive application, but I'm asking about your position that potentially January 17, 2024 is a date when standing attached. Does it work that way, or do they have to refile the lawsuit?
No, I don't think it works that way, if Your Honor.
Why did y'all say that?
Say again?
Why did y'all say that it?
Well, I think under the Coderre case, the original complaint is a nullity, and the correct thing to do is dismiss it, and then the ACC, if it wanted to, could try to refile based on its subsequent, what it believes is, authority that it now has.
I mean, under your standing theory, they would simply need to have a vote and then refile if I were dismissed based on lack of standing.
Yes. So I think if there were questions as to whether or not that standing, or whether or not they had standing as of the original complaint, if that had been raised, I think you can't make an argument that standing attaches any time before that vote. And so, and maybe this is why there's no case law that says the court's subject matter jurisdiction, that a court can obtain subject matter jurisdiction retroactively. So we do think it's a nullity that should be
Mr. cites my colleague Judge Robinson's case, and I believe it's pronounced Gao, G-A-O, as being on all fours with this situation. What's your response?
We obviously disagree. Your Honor, Gao does not so hold that subject matter jurisdiction can be conferred retroactively. Gao was a case in which a shareholder in a corporation sued the corporation. There was no question that the court had subject matter jurisdiction over that dispute. The corporation then asserted counterclaims back, and before it asserted those counterclaims before taking a vote. It then later took the vote and filed second amended counterclaims, and Mr. Gao, if that's pronounced correctly, moved to dismiss the first amended complaint on the grounds that it didn't have standing at the time that he filed the first amended complaint. The court found that that was immaterial because it in fact was a nullity. It was no longer that operative pleading. It didn't have a matter of whether the court had jurisdiction to hear the dispute, because Mr. Gao actually brought the dispute. I think the difference here that is made clear is there is a competing action here. If I'm trying to think if you can analogize, if you think of the same situation, if Florida State University would have brought this lawsuit in North Carolina, the ACC would have counterclaimed before it took a vote. Maybe that doesn't, it didn't have the authority to do that, but then it later gets the authority and files new counterclaims. Well, we're still in the same courtroom, and it is, as the court found, immaterial. Mr. Cooney's going to point you to paragraph 34 of that case, which says that the following compliance with the bylaws is immaterial. Clearly, that was about the facts and situations of that case. Following compliance with your bylaws is not immaterial. But if you look down to 35, the court goes on to say, the court concludes that despite the failure of the board to comply with Sonova US's bylaws prior to filing its counterclaims, Gallo's first argument against standing fails as to the second amended counterclaim. So if we were arguing that the second amended counterclaim didn't have standing, maybe that would fail if the ratification was appropriate. But it does not relate back to a prior plea. Does that answer your question, Your Honor? So we think, that's the first big point, that we don't believe subject matter jurisdiction relates back, and this goes to the kind of way our argument works. It should be dismissed. At a minimum, this court should not proceed based on an amended counterclaim that has not been, there was not the initiation of litigation, which actually falls into the second argument about whether or not the ACC ever complied with its constitutional obligation to take a vote for the initiation of material litigation. And I think the declaration of James Ryan, President Ryan from Virginia, ECF 46.3, makes clear that that's not what the January 12th post-filing meeting where they claim it was ratified, that's not actually what was voted on. He states in paragraph, sorry, I've lost it, but can't get the number of the paragraph. Basically, the vote was that we approve the filing of the amended complaint inclusive of the claims that were in the original complaint. But approving an amended complaint is not the same thing as approving the initiation of litigation. The laws in the Constitution are very specific. You have to have the vote to approve initiation. And so the attempted ratification did not do that. All it approved was the next steps in already initiated litigation. And it's paragraph 10, I apologize, Your Honor. It says that it's approving the amended complaint. Which then gets you to, I think, what the ACC's sort of, what their next argument is, the next logical one they have to make, is that they didn't have to take a vote. And I think...
Well, before you get there, I thought your primary argument was based on Town of Midland, which has a statement which Mr. Cooney says is dicta that shouldn't control me, but that statement is I'm blanking on the phrase, but it's subsequent events cannot confer standing retroactively.
Yes.
Is what that case says in the declarative statement. What is that not? I mean, is Mr. Cooney right? That's dicta that I shouldn't consider as binding or at least directional for me.
Mr. Cooney is correct that statement was not, it was not essential to the holding in that case because it found standing on other grounds. I would say it was direction from the North Carolina Supreme Court as to how this doctrine would apply in this exact situation. Less than 6 months ago, the court went out of its way to say it. And it really is just an application of the Coderre case, original complaint as a nullity, and it cites 2 other cases. I think that that's just I think that Your Honor hit it right on the head. Standing is measured at the time pleadings are filed, and subsequent events cannot confer standing retroactively. I think that's a statement of the law. It was not essential to the holding in that case.
All right.
So as to whether or not a vote was even required, and I think first it's just a remarkable, I think, proposition that a member association can sue one of its members without getting the approval of its members. But assuming that is the position the ACC is taking, they have 2 bases for that. First, according to the affidavit of President Ryan, the ESPN agreements allowed for, or as he said, imposed a contractual obligation and constituted pre-existing authorization of the members to file a lawsuit against Florida State to stop them from challenging the grant of rights. Your Honor, I'm happy to answer your questions, but that is not what that provision says. I know it's not in the scrutiny we represent. It's no longer remains confidential, but what that provision, so I will say what that provision says is you've got to take commercially reasonable actions. Those actions do not include any obligation that you spend money on counsels, on legal fees. And so I think that's an overstatement of what that provision says, and it certainly was not authorization of the members that would thereby mean you didn't need to take the vote that was specifically required by the authorization.
All right. So your contention is that the obligation to engage in commercial reasonable efforts as a defined term under the relevant agreements does not require the ACC to initiate litigation to protect the ESPN's rights under those agreements, and therefore there would need to be another step, and that other step is provided by the Constitution, which provides it 6.12, maybe get the numbers conflated, but there, and that is the requirement that there be a 2/3 vote in favor of material litigation.
That's exactly correct. And I would correct, I misspoke. The term is commercially reasonable efforts, that it's defined as it's actions in the affidavit. But yes, some of those terms are used equally. So then that leaves the last way they can say that the ACC can say that it didn't need, or that it has standing as of December 21st when it filed the lawsuit, and this case is not material. Because if it was, they had to get a 2/3 approval vote. I would note they took the vote before, the ACC took that vote before it sued Maryland back in, I believe, 2012 in that case. They took a vote before suing Clemson earlier this week or last week. It did not do that for Florida State University. I think.
It was the day before yesterday.
Before yesterday, yeah. I would say material, in this case, they take the position that this case is not material. Material is first not an ambiguous term. It has a clear and ordinary meaning. The Oxford Dictionary defines it as significant, influential, or relevant, especially to the extent of a judgment, such as whether to file a lawsuit.
Well, as I understand the ACC's argument on material, the argument there is, look, all our lawsuit did was to seek to maintain the status quo. The parties have been operating under these grant of rights agreements, the first one from 2013, the amended one from 2016. Nobody has made any challenge to them. Everybody has received lots of money under them. There hasn't been any dispute about them. And our lawsuit, as originally filed, simply sought to have a court recognize what everybody has always understood these agreements to mean. And then they posit that we got approval from the board, the 2/3 majority of the board, to initiate the first amended complaint because that complaint contained allegations against Florida State in particular, along with damages claims, that is, claims for relief allowing for damages awards. And I imagine what Mr. Cooney will tell me is that because the lawsuit that was filed the other day against Clemson also includes damages claims against Clemson, and that's why the ACC elected to get approval from the board to file that lawsuit. What do you say about the status quo argument?
So status quo does not mean material. I think you have to look at the context. Just think of the context of a preliminary injunction. The purpose of a preliminary injunction is to preserve the status quo, but, Your Honor, courts don't impose preliminary injunctions unless irreparable harm will be caused for them. Irreparable harm, in our opinion, means it must be significant, it must be influential, it must be material. Otherwise, this court will not issue a preliminary injunction. So I just think the status quo argument is just there's no correlation between maintaining the status quo and whether something's material. Certainly maintaining the status quo is material for the ACC, and upsetting the status quo is material for Florida State.
All right.
The other thing I would say, in the same argument, the ACC points to the definition of material for material media rights agreements, and I think following the textualist approach that the ACC uses on the sovereign immunity argument, you would say, well, the ACC knew how to define material in that context, and it actually gave the commissioner and the president of the board's discretion to determine whether an agreement was a material media right. The provision of litigation certainly didn't give the president or the commissioner that discretion to make that determination on its own. It's a clear contractual term that I think is a question of law for this court to interpret. They have said it's a question of fact, and all I say about that is to the extent the court believes it is a question of fact, it's a question of fact that will go to this court's subject matter jurisdiction, and we believe we need the right to take jurisdictional discovery on that so that we can find out about the conversations that President Ryan says ACC management had with other members about whether this was actually material litigation, and that the court should have that information before deciding whether it would have subject matter jurisdiction.
Well, let me ask you this. As I understand it, the ACC makes an argument along these lines. That is that, look, we're an unincorporated association under Chapter 59B of the North Carolina General Statutes. As an unincorporated association, we're a voluntary association. Under North Carolina law and the law of a lot of places, courts are not to interfere with the internal affairs, internal governance of a voluntary association. That includes, according to ACC, interpretation of the bylaws. And here we have a bylaw provision which the ACC has determined in this context whether something is material litigation or not. They made a determination that it's not material litigation, therefore they don't need to bring, they didn't need to have two-thirds approval from the board to bring it. And that they argue that their judgment in that respect is only set unless the court were to conclude that their judgment in that regard was unreasonable, or that it perpetuated, it was derived pursuant to fraud or collusion or duress or other equitable concerns of that nature. As a result, as I understand the argument, it's that, Judge, we put forward evidence from our decision maker who says this was not material litigation. That's a reasonable position given our argument about status quo. Therefore, your opportunity to review that decision is limited, and you ought not upset our voluntary association's internal governance determination. Sort of take that argument on its own terms. I mean, is that right? I mean, does that argument naturally flow the way they posit it?
No, Your Honor, it does not. The ACC has a constitution. That constitution is a contract between the members, and if it is unambiguous, it is for the court to determine the meaning of the, using plain language, determining the meaning of the Constitution. The cases cited by the ACC include McAdoo, Board of Gaston County Realtors. Those relate to due process type questions. Whether the association has applied their procedures in a way that is reasonable. And the court should not second guess the internal affairs and operations.
Well, is that what those cases say, or do those cases say that the court is to determine whether or not the internal procedures have been followed? And if the internal procedures have been followed, then the court is not to provide exacting scrutiny or is otherwise to defer to the decision that the entity, that the voluntary association made pursuant to those procedures.
Yeah, I think maybe we're saying the same thing. I think it's right. You've got to follow the internal procedures, and the court should not second guess those. Here, though, we're talking about the contract, the ACC Constitution. So we think it's a lot more similar to the Atkinson case from this court, where the court defined what, I think that was in the bylaw, but defined what the term proceeding, I think in the context of legal proceeding meant. And it said it was for this court to determine that because it is a plain and unambiguous term used in a contract, and that's a question of law. And so that's what we believe in looking at the ACC contract, what the ACC contract means, what they should do. This is not about the internal affairs and this court second guessing sort of their procedures. It's whether or not they
So
can
the deference that I would be, the deference that the ACC would receive as a voluntary association would be in its decision to initiate the litigation, which was the end result of their adherence to their internal procedures. I could evaluate whether they followed their internal procedures. I would have to give deference to the decision that they made ultimately, which is to bring a lawsuit. Is that right?
If there were procedures for the initiation of a lawsuit that were followed, a vote, do that, and there was some good faith, or not good faith, but they made an interpretation of how this vote is required, what they should do, then I don't think that court should second guess those sorts of procedural decisions. But in the first instance of whether to take a vote, that is a requirement of the Constitution, and they can't say, we don't think it was a requirement here. I think it's a contract that all the members certainly understood that in order to initiate material litigation, there would need to be a 2/3 vote. There was not a 2/3 vote.
All right.
With that, I'd like to move on to the sovereign immunity argument.
Okay.
And I think these will be relatively quicker. First, the waiver of sovereign immunity requires a clear and unequivocal declaration by the state legislature, in this case, Florida. ACC has offered two sort of acts that it contends could be these declarations. The first is the Florida Statute 1001.72 that gives the Florida State Board the authority to contract and act on behalf of the Florida State University, and it says it can sue and be sued in all courts of law or equity. The ACC points to it, says Florida follows a textualist approach. All courts of law and equity doesn't exclude courts in other states, and so that's what this includes, the courts of North Carolina. The textualist approach, when you're dealing with sovereign immunity, the 11th Amendment right, is not what the law requires. The law requires the most restrictive interpretation possible. That's the Maynard decision stands for that proposition from the 11th Circuit.
The 11th Amendment sovereign immunity is a different animal from state sovereign immunity, right? The 11th Amendment sovereign immunity is about whether or not there's sovereign immunity from suit in federal court, and you have judge-made law in North Carolina that deals with sovereign immunity that has to hailing a sovereign into the state courts of North Carolina.
Yes, but I think that the rationale from the Maynard Court would apply in this context as well, where it says a state does not consent to suit in federal court is not a clear and unequivocal declaration merely by consenting to suits in courts of its own creation. And again, it is in the context of federal court, but nor does it consent to suit in federal court for other state courts or in federal court by stating its intention to sue and be sued. And I think that logic applies here. This court should follow from Florida's, in deciding whether Florida has waived its sovereign immunity, should follow the most restrictive interpretation of that statute.
Let me ask you, is the state statute from Florida even relevant in light of the Farmer versus Troy University's decision from the North Carolina Supreme Court? Because in that case, the Supreme Court of North Carolina decided that where there was a sue and be sued clause, and we have that here under, I'll let you talk about that, but at least Mr. Cooney at ACC argues that we have that here in the Unincorporated Association statute under Chapter 59B. And so long as you have a sue and be sued provision in the statute, and you have commercial rather than, or as opposed to governmental activity, you have business activity in the state, then that's enough to constitute an express waiver of sovereign immunity. And they decided that is the Supreme Court of North Carolina decided that despite the fact that the Constitution of Alabama provided that the state of Alabama or its state agency would never be a defendant in any court of law or equity, which is a stronger statement of sovereignty or sovereign immunity than what we have from Florida statute, which has this definitional issue that you all are fighting about, whether courts of law and equity mean only in Florida, as Florida State says, or means anywhere in the country, as the ACC says. But our Supreme Court said, as long as you've got sue and be sued, as long as you've got business activity, it doesn't matter what the state, what Alabama or what Florida may say about their exposure to suit in foreign jurisdictions. North Carolina says you've expressly consented to suit here. Respond to that.
I think the first thing I would say about it is if Florida State University had registered as a nonprofit corporation in the state of North Carolina as a distinct legal entity that was agreeing that it could be sue and be sued here, then Farmer versus Troy University would be directly on point. You're right, Your Honor.
Well, does Farmer say that Farmer involved two overt acts that it talked about? One was to register with the North Carolina Secretary of State as a nonprofit corporation. The other was to have a certificate of authority, or to obtain a certificate of authority. But did the Supreme Court talk about those as these are the requirements that a sovereign must take in order to have waived sovereign immunity, or was it simply that this is evidence of consent? Because we're talking about a case that follows the Hyatt case, which had determined that as a constitutional matter, all states have sovereign immunity except when they consent. And the United States Supreme Court left undeclared what constituted consent. And then the North Carolina Supreme Court in Farmer decided, well, we're going to talk about what it means to consent. And in this case, those were the facts involving Troy University from Alabama. Mr. Cooney's argument, the ACC's argument is, well, if those kinds of actions were sufficient to connote consent in the Farmer case, certainly Florida State's activities, business activities in North Carolina pursuant to Chapter 59B, which contains a provision that allows for suit to be brought by the association and suit to be brought by the member, where they have earned millions of dollars, where they have competed in countless athletic contests, where they've attended innumerable meetings and have engaged in the leadership of the conference in North Carolina. All of that would certainly satisfy a court examination of whether there was consent to be sued in North Carolina, again, under Farmer.
I don't believe it does, because if you look at the difference between the Nonprofit Corporation Act and the Uniform Unincorporated Nonprofit Association Act, the difference is in what those two entities are. First, Florida State did not register as an entity in North Carolina. It did not get their certificate of good standing, or whatever the document was. All it did was join as a member. It joined as a member of an association. And as a member, what the statute that the ACC relies on, that they claim to be a sue and be sued statute, it makes clear that the ACC is a legally distinct entity from its members. And so in a nonprofit corporation, for a nonprofit corporation, that's the exact opposite. The corporation is the entity that is governed by that act. This provides the members of associations with some protections to say, you're not liable for the conference or for the organization. And so what that clause is saying is the ACC is a legally distinct entity with the ability to sue and be, it doesn't use the word sue and be sued. It says a member can sue on behalf of the association, and it says the association can sue a member. It does not say where. It doesn't, and certainly it would come as a surprise to Florida and possibly many of the other members of the ACC if that was found to be a clear waiver of sovereign, clear consent to suits in the courts of North Carolina.
Well, of course, this is all recent law. I mean, the Hyatt case was, I believe, 2019, and then the Farmer case was from, I believe it was November, December of 2022. And there is a rescrambling of the eggs here a bit, because there had been a rule of comedy that had given discretion to a state as to whether they would afford sovereign immunity to a sister state. And that was the argument that University of Maryland had made back in 2012. And the North Carolina court elected not to afford comedy, so that the suit, so that the sovereign immunity was not extended to Maryland, and the case proceeded in North Carolina. That whole regime is gone now based on Hyatt.
Yes, and I think so. If you look at that, you have to find consent from the state now, and I think the distinctions between the Nonprofit Corporation Act and the Uniform Unincorporated Nonprofit Association Act show that this is not the same thing. There is not the same level of subjecting yourself to the courts of North Carolina. You're not registered. You're not. And Troy had an office. Troy University had an office, had a recruiting office there. They subject to jurisdiction there. That is not the case if you are a member of an association.
All right.
The last point on sovereign immunity, I'll touch on quickly. The FSU board, the ACC claims that the FSU board waived any personal jurisdiction defenses, including sovereign immunity, by opposing the ACC's motion to seal. They claim that opposition was a general appearance. but we believe our jurisdictional defenses were preserved in our stipulation of service, where we preserve all jurisdiction, where the FSG preserved all jurisdictional defenses it may have. Under Riles, this put the ACC on notice. That should be sufficient. In fact, here the ACC spent several paragraphs explaining why they did not believe the doctrine of sovereign immunity applied, so they were certainly on notice, and it was preserved. None of the cases cited by the ACC included a pre-existing preservation. I would also say that sovereign immunity is a little bit different than the typical minimum contacts type waiver, and that's because you have to have a clear and unequivocal declaration. And I would point the court to the Mullis versus Seacrest decision, 126 MC App 91, where the defendant was allowed to amend an answer to raise an affirmative defense of sovereign immunity. And that case was reversed on other grounds, but that principle was then approved by the Supreme Court in the News and Observer versus McClory case, 251 NC 211, where the court actually found that sovereign immunity in that case was waived, but in that case it wasn't raised until an oral argument on judgment on the pleadings. And so you have, I think there is a more exacting standard than there is for minimum contacts, and that's because it requires a clear and unequivocal declaration. The last point is that makes sense. I said that it can be asserted as an affirmative defense. The courts of North Carolina also look at sovereign immunity under a 12b6 standard. The Green versus Kearney case did that, and so we don't believe it was waived. The last argument I want to touch on is rightness, whether there was an actual and justiciable controversy. The North Carolina Declaratory Judgment Act does say that you can ask for a declaration before a breach. We do not disagree with that. There is also the doctrine, though, of there has to be an actual and justiciable controversy in order for the dispute to be right. And the cases cited by the ACC, Board of Gaston County Railroads, McAdoo, and others recognize this distinction, and in many instances dismiss cases because they were premature. We will acknowledge an issue of sort of line drawing. It can be difficult to know when something springs into an actual and justiciable controversy pre-breach. But I think everyone knows and would recognize that the ACC couldn't have gone to court in 2013 and said, please just give us your blessing of this grant of rights and let us know it's enforceable when nobody has challenged it. I think the Gaston County Board of Realtors said it best when they said you can't get a judicial decision to put on ice in case a dispute ever arises. So here there was clearly, there was obviously negotiations, but the case law has said, or statements, the case law has said that litigation has to be unavoidable and there should be no impediments. And we believe a required vote of the Florida State University Board before it can initiate litigation is just such an impediment. You can't preordain what the vote of a public body would be.
The ACC argues that, or alleges that Florida State's president had individual meetings with each of the Board of Trustee members to secure their language, to secure their affirmative vote for the filing of the lawsuit, and that promptly upon obtaining that, all those approvals, then had the vote on the 22nd.
That's how we go.
They also point to a filed, or an issued copy of the complaint that was put out by, I think, the Florida State Press Office. I'm not exactly sure who put it out, but there was a copy of the complaint that was distributed that was issued in the morning before the Florida State meeting. And then they also point to comments that the president made, comments that members of the Board of Trustees made, comments that were made in a board meeting in August, comments that were made in a board meeting in February, all of which the ACC argues showed that Florida State intended to bring litigation, that they were not going to sit idly by, and when they learned, because of the notice of this meeting, it was imminent that the actual case of controversy was crystallized.
Couple of things. First, the leaked copy of the complaint was the next morning after the ACC had filed suit, and I don't believe it was the FSU press office. I don't think we know.
I'm struggling with my memory on that too. I don't mean to.
I think it was just a leaked copy, and I don't think it actually matches up perfectly with the complaint that was actually filed there. But the bigger point is that happened the next morning. The other thing is, if the FSU president had those meetings, I believe under the public records law, there would have to be minutes of those individual meetings and to secure a vote.
They intended to have the meetings to avoid the public record.
Yes, but the bigger point is, the board of directors, so the whole point of a board of directors is they exercise independent judgment. And so we're really just saying you should not preordain what that vote is going to be. We acknowledge it's a close call on this one. It was when the litigation springs into existence. But I would say preordaining a vote is on the other side of that.
Was it a unanimous vote when it actually happened? Is that on the record?
I don't know if it's in the record, and I don't know the answer to that question.
But they can't move forward without a vote.
Yeah, and the ACC, the Florida State cannot move forward though until they have that vote. And so or the Florida State can't move forward until it has a vote to authorize the initiation. It's certainly an impediment.
What I do about I've got the ACC's allegations that they made, and really what Florida State has posed is theoretical. That is, theoretically, until we had the vote, it wasn't a done deal, and we might have changed our mind. But I don't have anything from Florida State that indicates that the president was uncertain, or that any of the voting members of the board were uncertain. I don't have any evidence on which I can rely that suggests that it wasn't, as the ACC argues, a done deal.
I think you're right. There's nothing in the record. There's nothing in the record other than the theoretical. What would have happened? I would say that theoretical question is important. What would have? Obviously, every board member of every board exercises independent judgment. And what if the vote would have not passed? I think the question is, what would the ACC have done? They had a process server sitting outside of the meeting waiting. They didn't send a courtesy copy of the complaint after they filed it. They waited to see the outcome of that vote. And they had the complaint in their hip pocket, waiting for them to come out, and then served immediately once Florida State had initiated litigation, which actually dovetails right into the motion to stay. We believe this was a hip pocket complaint. We believe that's evidenced by the fact they didn't serve it. They didn't send a courtesy copy. They didn't serve it. They didn't serve it by overnight mail. They waited to see the outcome of that vote because they knew that was the only way there would be. Their lawsuit would be moot. It said you can't challenge the enforceability of the grant of rights provision. If Florida State hadn't challenged the enforceability of the grant of rights, there is no lawsuit. So we think that proves that it could not have been an actual and justiciable controversy before Florida State even made the decision to do that. Lastly, on the stay motion, that moves into the motion to stay. The court's well aware of the statute that allows court to stay litigation in favor of a competing action if it works a substantial injustice. Go ahead.
Let me just try to sort of jump into that, because both parties spend a lot of time, understandably spend a lot of time arguing about whether the ACC should have first filer status. And that under North Carolina law, even though we're guided by the lawyer's mutual case, which has has 10 factors that the courts are advised to consider, at least in some combination of those factors, deference is afforded to the first file complaint, but it's not automatic. It's not a ipso facto, whoever files first or whoever's accorded first file status, therefore their case gets to go forward. Let me ask you, you made a statement sort of early on in your argument about why, that you think that Florida, you forecast that you were going to talk about why Florida ought to be the place where these issues get litigated. I think summarizing the ACC's position would be along these lines. Why should a Florida court, where 2 members of the ACC reside, 2 of the 15 current members reside, decide issues involving the interpretation of the ACC's Constitution and bylaws, which by the Internal Affairs Doctrine that I am guided by would be controlled by North Carolina law? And why should a Florida court interpret the grant of rights agreements, which the ACC argues were entered into the last act causing those contracts to become effective occurred in North Carolina. Therefore, those contracts are governed by North Carolina law. So you've got 4 potential documents that need interpretation, all of which, according to the ACC, are governed by North Carolina law. You've got the ACC, who has been headquartered in North Carolina for 70 years. You've got 4 member institutions, the most institutions of any state represented in the ACC that are North Carolina based. You've got ACC argues this is where all the sources of proof are because the ACC servers are here. The ACC argues this is where the decisions were made about which Florida State is upset. Why, in light of all that, should the case, even if I were determined that ACC is not entitled to first file status, why should this case go forward before a Florida judge rather than here in North Carolina? I imagine I might hear from Mr. Cooney that, well, I won't go into that. I'll let Mr. Cooney speak for himself. Help me address that. Even if you win on first file,
Well,
why should this case be in Florida rather than North Carolina?
there's, I believe, about 11 factors under lawyers mutual. The court knows it's not a matter of, you don't have to find every single factor. It's a weighing and a balance. And so there are several factors that go in favor of Florida. Obviously, whether Florida has waived sovereign immunity is an important question to Florida. The Florida court.
See, how does that question get raised in Florida? Because sovereign immunity won't be an issue in the Florida case. The ACC has sued Florida. Florida State sued the ACC in Florida. Florida State has accepted jurisdiction in
Yeah.
Florida. The only place that sovereign immunity issue is going to get decided
Is out of state.
is here.
Yeah, I would say that it requires a clear and unequivocal declaration. It's obviously a matter of, and this goes really to the factor of local concern or foreign concern. It's a huge concern to the state of Florida. And so if there's no reason for this court to issue that decision, we would say it shouldn't. There also are important Florida questions of law. The unreasonable restraint of trade is brought under a Florida statute. There's an argument that we made in our motion to dismiss that I didn't touch on much because it's a 12b6 argument, not jurisdictional. But who has the capacity to bind a Florida state agency? That is certainly a very important question to the state of Florida. So those are important questions. We cited a case that I'm blanking on the name, but to the extent, and I don't know if we've agreed to this yet, but to the extent these contracts are governed by North Carolina law or contract law is largely the same across jurisdictions. And I think there's a case that says in Florida, specifically, they are very similar. So when you look at the issues of local concern, certainly I understand why the ACC wants to be in North Carolina. They understand why Florida State wants to be in Florida. There are important issues on both sides. And I do think this gets then to the first file status. The first file doctrine is because we give deference to the true plaintiff. And so I think you have to look at who is the true plaintiff, and that factor gets a lot of weight.
Well, let's talk about that. Who is the true plaintiff in this case? Florida State says it's the true plaintiff. But usually when you see, you see an examination of who the true plaintiff in a lawsuit or in a litigation, you've got somebody who suffered damages. And usually the true plaintiff is the person who suffered the damages, and the true defendant is the one who's caused the alleged damages. Here, both Florida State and the ACC are seeking to get a judicial declaration about the very same contracts. Florida State wants to bind these contracts to be all of the remedies that Florida State seeks in its complaint in Florida are a judicial declaration. They're a declaratory judgment that the contract is not binding. That is, the grant rights agreements are not binding and enforceable. They're not binding and enforceable against Florida State. What the ACC is seeking is that those very same contracts are enforceable. So how is it that Florida State is the true plaintiff and the ACC is not? Aren't they both? Don't both parties actually stand in relation to this dispute as true plaintiffs, and then you do have a race to the courthouse?
I don't think so, because they are Florida State's media rights, and so Florida State is the one that is harmed by the contract. So we are challenging the contract. They are asking, as they say, for the status quo to say. And there could certainly be damages that arise out of that. The Florida State is the party who is challenging the enforceability of these agreements. They are the ones who are going to court asking for affirmative relief. And I think, I take your point that they're both declaratory judgments, but I think we would like
Speaking
to.
of, I mean, the remedies are just the mirror opposite of each other, right? Florida State wants the judicial declaration that these agreements are unenforceable, and the ACC wants a judicial declaration that these agreements are enforceable. And then you've got the added piece that there are damages claims that the ACC has brought. Florida State is not elected to bring down those claims.
I think I would just say that, yeah, I think if the party challenging the enforceability contract is the true plaintiff here. There are, and so I think we would get that. I will say, I don't have that off the top of my head. I will say, the last thing I would say is, we do think it would be, they focused on substantial injustice. Obviously, that's defined by the factors. We do think it would be a substantial injustice to allow the ACC to watch Florida State's conduct for months, lay in wait, and then when Florida State announces it's going to have a meeting, to race to the courthouse, file the complaint, wait to serve it, leave it in their hip pocket, and then serve it after Florida State decides to move forward. I actually think that proves the point that they are the true plaintiff. That's all I have, Your Honor.
All right, thank you, Mr. King. Mr. Cooney?
Thank you, Your Honor. If I could get the system on.
Let me ask out of the blocks. Mr. King had submitted a PowerPoint that dealt with this motion to dismiss but did not reference it. Is there any objection from the ACC about how we're doing it? I actually haven't reviewed it.
No,
All right, thank you. Go ahead.
as long as you don't give it any free. As long as you don't give it any free, you have no objection.
Always the advocate.
And with the court's permission, I've kind of reorganized this to focus in on the issues that Mr. King addressed. And so I may skip through some of the slides and I've moved them around. It won't be exactly the way the presentation was that I gave to you. And I hopefully I've shortened it, which I know the clerk will be glad.
First bit.
So what I'd like to do is talk a little bit about one of the things that Mr. King mentioned at the end, which was that there are issues about who even signed the grant of rights, whether it was authorized or not. And when you take a step back and you look at this lawsuit ultimately is about the integrity of agreements, the integrity of promises, the integrity of the way parties deal with each other over a period of years. And part of integrity is accountability. It's an important part of it. Is a party going to be accountable for its promises? Is it going to be accountable for what it says? Is it going to be accountable for representations it makes? And the issue I've run into, and one of the issues they raise, in their motion to dismiss itself, is when they say, in truth, the Florida State University Board never cast any vote to approve the grant rights, which got my attention. Because I immediately began wondering why we sent them all that money over the years if they never entered into the contract. And so I went back to, as most lawyers do, to the source document, to the grant of rights. And there's the grant of rights. It's signed by the member institution. So far as I know, Florida State doesn't deny it's a member institution. It's signed by the president, and it says Florida State University. And then when you look at the warranties provision, you see one of the warranties is each member institution, that would be Florida State, represents and warrants to the conference that the member institution, either alone or in concert with an affiliate entity, has the right, power, and capacity to execute, deliver, and perform this agreement and to discharge the duties set forth herein. Then it goes on to say the execution, delivery, and performance of this agreement and the discharge of the duties have been duly and validly authorized by all necessary action on the part of such member institution. That's what they said in 2013. We've authorized this. And then now in 2023, or 2024 when this was filed, they claim they never authorized it. Both things can't be true. And that's one of the things that we've been struggling with is the arguments keep shifting on us a little bit. And then they submitted their First amended complaint to the court. And in that complaint, paragraph 234, they said the ACC grant of rights and grant of rights extension had ensnared the media rights of Florida State. Well, how do we ensnare the media rights of Florida State in agreements they say they never signed or authorized? It's like whack-a-mole, Your Honor. And that's part of some of what we're dealing with here, which led to the lawsuit to begin with on the part of the ACC. Now, what's not in dispute, as the court pointed out, is that the ACC is a nonprofit North Carolina unincorporated association. It's been here for 70 years. Florida State's a member institution. It continually participated in and exercised control over the ACC for 30 years. The grant of rights is a North Carolina contract. The grant of rights will be governed by North Carolina law. So what Your Honor has here is a North Carolina organization suing one of its members over the interpretation of the contract governed by North Carolina law in North Carolina, just as it's permitted to do under 59B7, where it says a nonprofit association may assert a claim as a member. That is the right that this juridical organization was given to sue a member. Now, working my way backwards through Mr. King's argument, I want to deal with rightness. And I'll not be long on it. First of all, Mr. King suggested that this related to Article 3 rightness, that you had to have a case of controversy. It doesn't. Article 3 doesn't apply in the North Carolina courts because the federal courts are courts of limited jurisdiction. That's why we have case of controversy requirements in the Constitution. In North Carolina, the only issue is there enough of a concrete controversy so that it makes sense for a court to weigh into it? Do the parties have enough of a stake? Is there enough of an argument? And that's very different from case of controversy. But here, what we know, and this is the initial complaint that was filed, is that one of the promises in the grant of rights that Florida State made in 2013 was they would not take any action or permit any action to be taken by others subject to their control that would affect the validity and enforcement of the rights granted under this agreement. It's effectively a covenant not to sue. It's a covenant not to challenge. It's actually broader than a covenant not to sue. And so and then paragraph 114 of the initial complaint alleges specifically the board's going to meet tomorrow. The purpose is to initiate litigation, and they're going to challenge the validity and enforceability of the grant of rights and amended grant of rights. In other words, the board's going to breach this contract tomorrow. And what Florida State doesn't recognize is that their lawsuit by itself is a breach under that non-dispute provision of the grant of rights. And the ACC doesn't have to wait until they actually breach in order to bring a claim. And that's precisely what it did. The case law is clear about that. We knew they were going to breach the agreement. We knew they were going to breach the agreement tomorrow. And in fact, they did breach the agreement tomorrow. Now, Mr. King somehow suggests that we held this in our hip pocket. I mean, first of all, you can't just send it certified mail. It wouldn't have gotten there on the 22nd anyway if we'd sent it out the night of the 21st. But Florida's fairly particular, and North Carolina law is a little bit opaque on how you serve a sovereign institution in another state. And so we decided that, at least looking at Florida law and interpreting it under Rule 4 of North Carolina law, we need to personally serve the chairman of the board of trustees, or the president, or their authorized representative. And guess where they all were on the morning of the 22nd? They were in that board meeting. We served them literally as soon as the meeting broke up. We served them within hours of filing the lawsuit. That's hardly the kind of hip pocket complaint that the court dealt with in Lamac, where they walked around with a summons and complaint. I think it was for 6 weeks. And you couldn't have served them any faster than we served them. They say, well, we should have sent a courtesy copy. We didn't know who was representing them in this litigation. We knew lawyers had been in our offices. We didn't know who the lawyers were going to be for the litigation. Who would we send a courtesy copy to other than Florida State? And guess what? They would have sued us immediately upon receiving it anyway. So the other thing is this lawsuit copy that we located on the internet. And this is a copy of the lawsuit. And it was posted by fsu.edu. It's the news service for Florida State using the fsu.edu web address. It was posted actually on the 21st, but it was modified the morning of the 22nd at 8:12 a.m. And it actually contains an allegation at 8:12 a.m. on the 22nd that the Florida State University Board of Trustees in a publicly noticed meeting on December 22nd, 2023 authorized the initiation of this action. It alleges the board had already approved it before the board had even met. I don't know how you can get more imminent than what we had here. And clearly, this was right when the conference filed.
Mr. King makes a point of saying that, well, it was the next day. It was after the ACC filed the lawsuit. It really isn't relevant to the ACC's state of mind at the time that they filed their lawsuit on December 21st. It wasn't part of what they knew about the existence of the controversy, so it really shouldn't have much bearing on or any bearing on my decision on that particular issue. What do you say to that?
Well, respectfully for Mr. King, rightness doesn't turn on a subjective state of mind. I can believe somebody's going to do something and there's no objective evidence for it, and the court could find it's not right. Rightness is a judicial determination that you make based on the facts and circumstances. And they're the facts and circumstances in this case around whether or not breach was imminent. And we cited case law to you where the Court of Appeals has specifically said, well, they filed a declaratory judgment because they were afraid a lawsuit was going to be filed. And guess what? A lawsuit was filed. And we can consider that to say it was right when they filed it. It proves it was imminent. So you have the advantage both taking an objective look at what the facts and circumstances are and being able to look at all the facts and circumstances that we know existed around that time before you make a determination on whether breach was imminent. And so what we didn't know at the time doesn't mean that the court can't consider it. And the Court of Appeals has specifically authorized that. What we did know at the time is they were getting ready to sue us. And we were right. And the court's entitled to consider that. And we've now given you, and the main reason we gave you that lawsuit on the morning of the 22nd was to meet this argument they keep making that, well, we could have changed our mind. It's a funny thing to say you could have changed your mind when your own news service is putting a copy of a complaint out on the internet that says you've already made up your mind. And, you know, they're right in one sense, because we've all got free will, and everyone can always change their mind. But the standard isn't, well, can you change your mind before you actually breach? In that case, you'd always have to wait to breach. The question is, as a reasonable person, as a practical matter, was breach imminent? Breach was imminent as a practical matter. Now let me talk about authority, which occupied a lot of Mr. King's argument. First of all, the way this initially came up was it was a 12b6 that we didn't alleged specifically there was authority. And of course, we're not required to do that under North Carolina. So it's not a 12b6 issue. But then they dropped a footnote that seemed to suggest standing in a 12b1 basis. And we are frankly left with a quandary because they really hadn't argued it other than dropping this footnote. But we know 12b1 standing does go to subject matter jurisdiction. And so rather than just say, no, we're not allowed to, or we're not required to allege authority, go pound sand, we said we need to address this in a way to let the court know there's more to it than meets the eye. And that's what we did, and then this is morphed into this kind of 12b1 standing.
Which allows me to go beyond the plea.
That's correct, and that's why we submitted the additional materials, knowing that you can go beyond the pleadings, and frankly, you know, we've got to show you subject matter jurisdiction. Once they
That's first.
Yes. I hate that word, but I do. Now, Your Honor, and I'll get to this again, but to anticipate, well, I don't want to anticipate where you're going, but to respond to some of your questions. You were talking about the broad language in town of Midland and in some of the other cases, that if there's no standing, there can never be standing. And I respectfully submit to the court, standing is a very broad term. And standing encompasses different kinds of things. And I would use the Lamac case that Your Honor did as one example. So there's what I think you can refer to as injury in fact standing. In other words, is this a party who's actually been injured, who has a cognizable legal claim? If you don't have a cognizable legal claim, you've obviously got no standing. And in Lamac, what you were trying to figure out is, all right, do these people have a direct claim under Delaware law for having been deprived of the ability to weigh in and vote? And you concluded, in fact, they did have that injury. But if they hadn't had that injury, if you concluded, no, that's not a cognizable claim, then they can never have standing. And that's what that case law is directed to. Cottrell is similar to it because, as I recall, that was the bankruptcy case where the corporation's in bankruptcy and, you know, some shareholder just decided, well, I'll bring on behalf of the corporation because, you know, they're not doing anything and I don't have any business doing it, but I'm going to do it anyway. That person can never, doesn't have an injury in fact, that person can never have standing. But that's different than this case, because in this case, there's no question the ACC has an injury in fact. It's got a claim. It's got several claims. The issue is whether it complied with its internal documents in order to have the authority to actually file the claim. And that's a very different thing than whether you don't have a cognizable claim at all.
The ACC acknowledges that it had to follow its constitution in initiating the lawsuit, right?
That's correct, which is what it did.
Right. Okay. Go on.
Right, because the ACC...
And this argument is not fought on a contention that you know, the ACC was excused from the constitutional requirement. The ACC's argument is we complied with the Constitution in determining this was not material litigation.
Correct. Or there was ratification on January 12th, which under Gow makes it material what happened earlier.
And let me ask you the same question that I asked Mr. King. Gow is a decision from the business court from Judge Robinson. It was decided in 2018. The town of Midland is just 6 months ago from the North Carolina Supreme Court. And it's got that language that says subsequent events cannot confer standing retroactively. Now, they grade my papers. They're the Supreme Court. I mean, your argument asked me to consider that dicta and decide to follow my colleague's decision from 5 years ago.
No, it does not, Your Honor.
Okay, well, help me.
I mean, first of all, it is dicta. They concede it's dicta. But
But it's pretty directional dicta.
Right, but it deals with the injury in fact standing. And I direct the court, for example, the footnote in Willowmere from the Court of Appeals opinion, where the Court of Appeals said, all right, here's an association who didn't follow its bylaws, so we don't think it has standing, and then dropped a footnote saying, we've not been given any evidence that there was ratification. And across the country, courts have ruled repeatedly, yes, you can ratify the decision to file a lawsuit. Even Robinson on corporations talks about the fact that a corporation's standing is not defeated by its failure to follow the internal bylaws so long as ratification.
How does that gel with North Carolina cases that say that subject matter jurisdiction and standing is determined at the time the initial complaint is filed?
Because, again, it's how you define the standing. North Carolina law and Town of Midland are absolutely right. If you're looking at standing in the injury, in fact, the cognizable legal claim, you've either got a cognizable legal claim or you don't. It's like
the subsequent events that the Town of Midland case is talking about, you're positing that those are not the procedural requirements that must be followed. They relate solely to the underlying injury that gave rise to the claim.
If there is even an injury, or if it is even a legally cognizable claim. And that's the distinction that allows you don't have to, overrule Town of Midland, which I wouldn't ask you to do. You don't have to.
Thank you for that.
You don't have to overrule Judge Robinson, and you're really going to be with that. But those two things are consistent with each other. Because when you take a look at the standing cases, Burgess and Cottrell and Lamack, where you were looking at them, those all dealt with, is there even a cognizable claim? Is this a claim that you can bring ever? And if you can't bring the claim, you can never bring the claim. It's a little bit like if I am getting ready to go in for surgery and I file a lawsuit against my surgeon for malpractice, it's going to happen during the surgery. I go into surgery and the surgeon commits malpractice. I didn't have standing to file that first complaint. I had no injury. I had no legally cognizable claim. But this isn't that case. There is a legally cognizable claim, particularly once you find it's right. Then it's absolutely a legally cognizable claim. And if it's a legally cognizable claim and it's simply a question of following your internal procedures, then ratification is a valid, is consistent not only with what the Court of Appeals forecast, but also what other courts across the country have done. And I don't, Town of Midland, obviously we have to respect the Supreme Court's language. But the fact of the matter is Town of Midland wasn't dealing with the situation we have, where we have a cognizable injury in fact, cognizable claims, a right dispute, and the issue is whether or not you can ratify an alleged failure to follow your internal procedures as an organization.
So essentially, your legal proposition is that ratification is available if the injury in fact occurred at the time of the initial suit.
Correct.
Did you argue it that way in the brief?
I believe I did. I apparently didn't argue it that clearly. And part of it too is taking a look at Gow, when I saw Gow, and trying to say, all right, I've got Gow here, and I've got broad language in Town of Midland, and I've got broad language, but when I look at those cases, they're all dealing with, is this a cognizable legal injury? They're not dealing with internal procedures the way our case is. And then I see the footnote from the Court of Appeals decision in Willowmere, which we did cite to the court, to indicate that, ratification would have made that case differently. And then we looked at the case law across the country that also ratification can authorize a previously filed lawsuit. And, and we look at Robinson on corporations, and so we see these things, and how do we marry these things up in a way that's consistent? Well, again, looking at the case law, standing includes both, do you have a cognizable legal claim at all? Does this person have a cognizable legal claim? And also encompasses, did you comply with your internal procedures to bring the claim that you have? And it's the internal procedures to bring the claim that you have that Gao addresses, that the Court of Appeals forecasts, and that none of the other cases that talk about once standing isn't there, can never be there. None of those cases deal with those kinds of facts where you've got an internal authorization process of an admittedly cognizable claim. And that's what Judge Robinson was dealing with in Gao. Now, respectfully, Judge Robinson's decision didn't go off on, well, I had jurisdiction over Gao's claim. The sole thrust of that was whether you got jurisdiction of the counterclaims and whether he was going to dismiss the counterclaims for lack of subject matter jurisdiction. And this is a basic corporate law principle that when you ratify something, it is effective as of the time the act was taken, as if the act was validly authorized to begin with. Which is probably why we're here in business court talking about this, because I don't think the town of Midland was intended to overrule that basic principle of ratification. A principle of ratification that applies not only to organizations, but to private corporations and municipal corporations. And so you've got to read that ratification language in the context of what those cases with the broad standing language actually deal with, as opposed to simply apply a dictum to something that's different than those cases. And I apologize if we hadn't articulated this as clearly as I hope I've articulated it now. But standing is just a very broad concept that encompasses a lot of different things. And all that language about once you don't have it, you can never have it, deals with cognizable legal injury and cognizable legal claims, not with people with claims who maybe don't follow their internal procedures. Now, Your Honor, I've kind of skipped ahead a little bit, but I do want to talk about, since we've talked about that in ratification, what I do want to talk about is the question of initiation of any material litigation. Because obviously, because you don't need to wrestle with any of this if you find the initial complaint was both right and fell within the power of the conference to file without a vote of its members.
Let me sort of, I know you've got to argue about it. When I'm looking at that, let me ask about the standard that I'm applying to determine this argument about material litigation. What I have discerned from your briefing is that, as I said in my question to Mr. King, that there is some deference that I should afford to the ACC in making its determination as to materiality, and that so long as that determination of materiality is reasonable or not arbitrary, capricious, and that line of words, then I will not exert judicial review to impose my own determination of materiality. Is that a fair assessment of your argument?
Yeah, if I could play around with it just a little bit. I think our argument is, in the first instance, the ACC has the right to interpret its bylaws to determine what procedures would follow from In this case, what we have is a required absolute 2/3 majority for the initiation of any material litigation. It's not any litigation, it's any material litigation. Material is not otherwise defined. So the ACC in the first instance has the right to say, all right, what does that mean? And how does it apply to this situation? And we believe that if they do that and present you reasons for it, which we've done, that you can only set that aside if you find that was an arbitrary and capricious determination.
Now, Mr. King's argument in response to that is, look, this is a constitution of the conference, and that is a contract between the conference and all of its members, and that provision is there for the benefit of the members, including Florida State, and that in the event that the ACC does not follow its own internal procedures, then relying on cases like Peninsula and Homestead and Atkinson, we have a right to challenge that. And if we establish that the predicate for bringing the lawsuit was not properly established, then there's no standing and the claim must be dismissed, albeit without prejudice.
So the problem with that is if this said the initiation of any litigation, they would absolutely be right.
Well, so the question then becomes, all right, so it says material litigation.
It does.
Does the fact that it says material litigation remove from the court the ability to determine that as a matter of contract interpretation and instead vest that in the ACC to decide for itself whether litigation is material?
In between, Your Honor. The ACC gets to decide in the first instance. I think we'd all have to agree with that. I mean, because it's their bylaws, it's their organization. But
Subject to review, and the question is, what is the review?
the question is, what's the standard?
Right.
And so what they're asking you to do is substitute your judgment.
Well, they're asking me to decide as a matter of contract interpretation whether or not the Constitution's been followed.
Well, they're asking you to decide as a matter of contract interpretation whether this was material.
Right, because the Constitution
Right.
embraces the concept of materiality.
Right, but had we concluded it was material as we did when we brought affirmative claims, we are required to take a vote. So it's not a question about what the procedures are, it's a question about whether the procedures were even triggered.
Well, but to your point though, if you had decided, if the ACC leadership had decided that the filing of the amended complaint was not material, your argument would be the same. That is that I would need to defer it and determine whether or not that's reasonable or not. And if you could make an argument that that was reasonable, then there would not be really judicial review of anything beyond an abuse of discretion type review.
Well, and that's the way it is with any bylaw. First, this was in the Constitution, but these are governing documents. And that's why the courts stay out of these issues, because they may interpret, a governing organization may interpret these words to mean one thing.
But don't these cases, McAdoo and Wilson and Nasker versus Landfalls and other, don't they talk about that so long as the association, so long as the voluntary association complies with its internal procedures, then there is going to be deferential review. But it leads to the court to determine whether or not there was compliance with the bylaws.
Right, but here the compliance with the bylaws turns on an interpretive term that's necessary for the governance of the conference. Do you have to convene the board or not? Do you have to take a vote or not? And in the cases they cite, it clearly did. If you're going to sue Crescent, you have to take a vote. If you're going to sue another homeowner, there has to be a vote. And if there's not a
And
vote.
here, if there's going to be material litigation, you got to take a vote.
Right.
Their argument is, well, then it's up to the judge to decide whether this is material or not. And that's not a deferential standard of review.
And we're not taking you out of the process, Your Honor. We're just saying
But
that.
you're just saying I'm limited to an abuse of discretion
Right.
type review, whether it was reasonable or not.
Correct.
Okay.
And that's the only thing that makes sense when you're looking at, because they're trying to figure out in good faith, and that's why President Ryan's affidavit or declaration was given to you, trying to figure out in good faith, what does this mean and does it apply to us? Does it apply to this situation? And they've taken a very nuanced approach, which is, look, if we're just preserving the status quo, we're just saying to the court, we've been operating this way for a while. We think we need to continue to operate this way. That's different than suing a member for damages. If the ACC wins every claim that was set forth in that first complaint, nothing changes.
But see, the flip side of that is if the ACC loses,
Which-
then the most valuable contracts that the ACC has would be found unenforceable. How's that not material?
Well, because the issue isn't, well, gee, what happens if you lose? If we'd sat back and done nothing, the same thing could have happened. The issue is what are we initiating? We're initiating something to preserve what's been going on.
Well, you're initiating a lawsuit with a hoped-for result, which is it would be a result to maintain the status quo, but you're opening up the possibility
Sure.
that your contract would be found unenforceable.
But that's inherent in any litigation. Now we're getting back to an all litigation.
Well, that's why, I mean, I guess, it's an odd provision.
It is.
in a
Which
constitution
is
of
all
this
the more reason why you should defer to it. Because it's not an unambiguous provision, and it calls for an interpretation. And we did,
Typically, when I've seen material litigation, it would be in the context of a corporate transaction, there would be a schedule that lists material litigation, and there would be a definition.
right,
Much like there's the material remedial rights agreement, or
definition of material media rights agreement.
yeah, that clause in the same, I think that's clause 3, and this clause we're talking about is clause 5. But you have a definition, and usually that definition would be tethered to amount in controversy or expected expense or some kind of marker like that.
And that one, to give you an idea of the interpretive, gloss over this is 5% of the gross revenues, or the discretion of the chair and the commissioner.
Yeah, what is your, you advanced the material media rights agreement in your briefing and in your PowerPoint. What am I to draw from that reference from the ACC's perspective? Because Mr. King has made the argument, well, all that the ACC has done by referencing that is to show you they knew how to define what materiality is in the context of a media rights agreement. They could have done that here with respect to litigation and just chose not to do it.
Well, the list of things anyone could do is obviously fairly long, but what it does show us is the ACC membership is comfortable in assigning the definition of materiality in everything but the most obvious case to the chair and the commissioner. That they have made that decision about money. And having made that decision about money, is it unreasonable to believe that there shouldn't be some discretion in terms of trying to determine whether anything is material? Now, I'm not arguing that
It's not
definition
there,
applies, right? Because it's not a defined term, but
It seems, I mean,
but it's a modifying term. Is the point?
the Florida State's argument is that if they intended to leave it to the discretion of the chair and the president, they know how to do that. They did that in the material media rights provision, they did not do that when it came to material litigation.
Right, but we're not arguing this was totally left to the discretion, because if it was totally left to the discretion, you might not have a role at all. But what we're saying is this is a modifier that's not defined elsewhere. That there was a process to try to figure out what it meant in the context of this skinny complaint that was filed with only 2 claims for relief, both of which were declaratory, and whether it would apply. And in the first instance, and this is more than merely a contract term, it's a governing procedural term. Because if they determine we think it's material, it triggers some procedures. If they determine it's not material, it doesn't trigger those procedures. And so, this is no different than, the conference deciding, let's say they're going to have a meeting on whether to expel a member, on how much time are they going to give the member to be expelled. What are kind of the implications of the process around it? Because it's not spelled out, you have to make some decisions, but there are some basics spelled out. So, I understand, the court's focus on this, but at the end of the day, the association has got to have the discretion to interpret this and not have a court come in and decide that there's another interpretation that's more reasonable. I mean, if it's arbitrary and capricious, then that's one thing. But that deference is critical to the way, particularly the way in which non-incorporated nonprofit membership operates. And so, I don't want to repeat myself, but they were presented with a quandary. They made some decisions. The decisions were, we're not going to seek affirmative relief. They could have sought affirmative relief. They could have sought an injunction. They could have sent me down to the business court and sought an anti-suit TRO and tried to restrain Florida State from filing its lawsuit. That was a bridge too far for them in terms of that provision. And so what they did is they asked the court simply to find the status quo. That the agreements we operate under for more than a decade mean what they say. And more importantly, that Florida State's has stopped from challenging them as a result of the acceptance of benefits. Nothing material about either of those in the sense of changing the relationship between the conference and Florida State. No damages, no injunctive relief, not changing the way the conference is going to be governed or what Florida State's rights are.
Mr. King made an initial argument that it would be material anytime the conference would choose to sue a member. How do you respond to that?
I have a hard time accepting that unless I know what they're being sued for and what the relief is. If a member's not coming to meetings on a regular basis, and we sue the court saying, and we sue them saying, you need to issue a declaration saying the member really needs to come to meetings, or you can take some action or something like that. It's hard for me to equate that with suing a member for damages, or suing to expel a member, or suspending a member. There are plainly actions we can take that change the relationship between the conference and the member. And that ultimately is kind of what this turned on. And how is the relationship changing? What are we asking for that would alter Florida State's rights or alter Florida State's pocketbook to damages or alter the way this conference is governed? And none of that was there in that initial lawsuit.
Is it a reasonable expectation for Florida State to believe that under the ACC Constitution, this provision will ensure that any litigation against us by the conference would have to be approved by a 2/3 majority.
I don't think so, and if I can flip it around, we've seen those provisions in some of the other, in the property owner's cases. If you sue a property owner, there needs to be a vote. If you sue Crescent, there needs to be a vote. That wasn't anywhere here. Quite frankly, I'm willing to bet when they drafted this clause, they never thought for a second that litigation would be erupting between the ACC and its own members.
But there was a,
Yes, but here we see, which is, again, it gets back to, you've got to interpret, you've got to give this organization the opportunity to interpret this and some discretion to do so. Now, the second piece of this, and I don't want to ignore it, and I do want to get to jurisdiction too, is the commercially reasonable. So, as President Ryan pointed out in his affidavit, the ACC was required to take commercially reasonable efforts to prevent what they were about to do. Now, they argue, well, commercially reasonable efforts don't include hiring attorneys because, look, it says you don't have to become obligated to
you can, but you don't have to.
yeah, you can, but you don't have to. And on top of it, it says not otherwise specifically provided for in this agreement. And when you look at the warranty provisions, and I'm not going to quote them verbatim because those are under seal, but the general import of the warranty provisions is that the conference has to take action to protect or prevent an infringement or violation of the rights that it has given under the ESPN agreements. Now, there's no way you can protect or prevent infringement of these kind of intellectual property rights without lawyers and courts, ultimately. I suppose you could, send a harshly worded letter, but the point is...
Why have this provision that doesn't obligate?
Because there are hundreds, literally, of other provisions in this agreement that also require commercially reasonable efforts that wouldn't require consultants or lawyers. For example, if a game gets canceled, they've got to operate in a commercially reasonable fashion to consult with ESPN and figure out when and if the game can be scheduled. If there are other issues, involving, a dispute over, facilities, for example. Again, commercially reasonable efforts. You're not required to hire a consultant to design your broadcast facilities through gyms and stadiums. So, this is a broad provision that's intended to apply to a lot of things, and it says except as otherwise specifically provided for. And that warranty provision is one of those exceptions. Plus, Your Honor pointed out, doesn't require you to, but you can. The other thing is, as of December 21, the ACC was incurring attorney's fees because they were going to sue us. So, to say that, well, you're not required to incur attorney's fees, when we're about to make you incur attorney's fees, gets back to the fact that this is a commercially reasonable action that was, previously authorized. Now, we're not saying it's solely the unanimous approval of the membership for this, because we could probably all think of something in which it would also constitute material litigation. But this was one of the bases on which the ACC was looking at this thing, saying, we've got a contractual obligation to protect or prevent infringement of these rights. And we're only filing something that is narrowly targeted to preserve that status quo.
Your argument is that the warranty and the definition of commercially reasonable efforts combined to effectively pre-approve this lawsuit. Is that right?
Not by itself, but it provides the added authorization, the added, all right, because you asked a question about would Florida State have anticipated that there'd be a vote before we sued. Well, in the context of this, you don't need to have a vote to take the actions necessary to protect or prevent an infringement of rights.
Even if that involved the initiation of material litigation?
Right, because that is...
I mean, is that right? Is that the argument?
Well, yes, I mean, on one level it certainly is, but it doesn't need to be the only argument on that. That can inform the reasonableness of the interpretation of the clause as well. Because arguably, if the ACC hadn't done what it did, it was placing itself in breach of the ESPN agreements. And breach of the ESPN agreements...
Arguably not, since it's not a mandatory requirement to incur costs.
But it is a mandatory requirement to protect or prevent the infringement of the rights. And that's an exception to that clause, because that's the otherwise specifically provided for in this agreement. So, you're on the precipice, if you do nothing, of being declared in breach of the most important contract you have. More important than the grant of rights. And so that helps inform the decision. Now, is that by itself pre-authorization? The court wanted to find that, we wouldn't argue with it. But it certainly makes the determination of material litigation more reasonable under these circumstances.
As President Lyons said, is after that.
Yes.
All right. I understand that argument.
All right, so on jurisdiction, I don't have that much time left, but I do want to address it. First of all, there are no issues of due process jurisdiction. They've got plenty of contacts. They don't deny they can't be sued in the state of North Carolina, but for what I'll call sovereign jurisdiction issues. So this is not a due process jurisdiction argument. So on sovereign jurisdiction, Farmer, I think, guides this case. Because Farmer is not about getting a certificate of authority. What Farmer did is it said, the United States Supreme Court precedent, the Hyde case, does not support the Court of Appeals' conclusion that a sue and be sued clause cannot constitute an explicit waiver of sovereign immunity. And then they go on to say, one Troy University registered as a nonprofit and engaged in North Carolina business.
This is evidence of consent.
Precisely. It accepts the sue and be sued clause. And
Do we have a sue and be sued clause here? Mr. King suggests we don't. You argue in your brief we do. Tell me about that.
we do. So we don't, it's not a broad sue and be sued clause. In fact, it's far narrower. Remember, the nonprofit sue and be sued clause is you can be sued on anything, everywhere, by anyone. And what the General Assembly did is they tailored this much more narrowly. They said, well, a member can sue on behalf of the nonprofit association. And then they provided a member can be sued by the nonprofit association for its claims. So this is a narrowly tailored consent that I think reflects the participation of a member in a nonprofit organization who doesn't, and it's certainly not the broad waiver that happened in Troy. It's solely limited to claims of the association. And by continuing to be a member of the ACC, they accepted that under the same reasoning as Farmer.
Does the fact that it's a narrower sue and be sued clause give Florida State more are they able to avoid the application of Farmer?
I would say it's to the opposite. Because maybe I'll use a term that might be inappropriate. It's a more humble waiver here than it is in Farmer. I mean, Farmer was quite broad. Once you come in, Alabama, we don't care what your law is. You're stuck. Whereas here, all we're saying is they are liable for the claims of the association. And again, this is a nonprofit association. It's run by its members. And it would be, if the ACC had to run to several different states to make a claim against one of its own members arising out of North Carolina law, that would defeat the purpose of having a North Carolina unincorporated association. The North Carolina Incorporated Association has to have the ability to sue its members for its claims. And the members are not engaged in a broad waiver that should concern the court from an equitable standpoint. I mean, it's not like I can sue Florida State, only the ACC can. And what I'd like to do is to take a couple of minutes, let Mr. Lawson talk to you about the textual approach of Florida law. The honor's right, obviously farmer governs the case, doesn't make any difference what Florida law says. You pointed out the distinction between Maynard in this case, because Maynard is an 11th Amendment case, and this is not an 11th Amendment case. I wanted to let Mr. Lawson talk to you very briefly about the way Florida courts read down the statute.
All right, before we do that, what's the time allocation, Lauren?
6 minutes roughly remaining.
All right, and how much time is Mr. King?
4 minutes, of
All
course.
right, let's take a break
All right.
now, and we'll take a 10-minute break. Actually, let's give the crowd, we'll take a 15-minute break to be sure everybody has an opportunity to take advantage of the break. And we'll be back in 15 minutes.
As long as the court that stands in recess for 15 minutes.